Hello. In this clip from our Justia webinar, Logic for Lawyers, Crafting Persuasive Legal Arguments, Ryan McCarl shares some tips and best practices for crafting effective and efficient legal arguments. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Some of the steps when you're crafting a legal argument that involves, if you want to sort of break it out into particular, more granular steps, is that you obviously start with the conclusion that you want, which is that your client wins. If you don't see any way to reach that conclusion, time to settle or decline the case at the intake stage. But assuming that your client has a path to victory, then that's your conclusion that you're trying to reach as an advocate. And then you're going to devise legally cognizable reasons, usually that are almost always backed by citations to authority. And then you'll kind of rank those reasons by strength. And by strength, I really mean which of these is most likely to persuade the judge or fact finder to rule in my client's favor. And then you have to identify how to establish each reason, because each reason is going to have premises, usually facts plus law. How do you establish them? And then you're going to want to support the legal premises with apt authority and the fact premises with admissible evidence that's also credible. And finally, you then structure the resulting pattern into a coherent, easy to follow argument. So the next thing we'll talk about is how to do that last step. Okay, so this is an argument map that I put together. It is intended to kind of show what this looks like in operation in terms of devising reasons and thinking about this concept of linked premises that I talked about. So at the top of the chart, this is the situation here is a securities fraud case and the element of scienter, which is essentially intent to defraud. So the question is, the conclusion that you're trying to reach as the defense attorney challenging this element is that there was no intent to defraud. So you have to then marshal reasons for that conclusion that you want. And in this case, I have one reason that adds up to that conclusion. And it looks like there are many premises, but they all add up to one reason in a way we'll see. So just working downward from the conclusion, the next row, you have a sort of factual conclusion or intermediate factual conclusion that we'll call the defendant Dennis had the same incentives as the investors. Standing by itself, untethered from a legal rule, it doesn't function as a reason because it doesn't directly speak to whether the element of scienter is met. So it needs to be tied to a rule that shows that incentives, in alignment of incentives between the plaintiff and the defendant has a bearing on this element of intent. So to the right, you have the same incentives rule. So the rule of law is if an investment promoter has the same incentives as the investors that they solicit, then they probably don't intend to defraud the investors. So once you combine that rule with the intermediate factual conclusion that Dennis had the same incentives, now those together function as linked premises that operate together to as a reason that the scienter element is not met. Then each of those linked premises will itself likely be challenged, and so that needs to be backed and defended. Some premises are going to go without saying and can sometimes be left implicit, but most premises are going to be challenged most of the time, at least the significant ones. So the same incentives. How do you establish this intermediate factual conclusion that Dennis had the same incentives as the investors? And there's for this one, you have two independent reasons supporting that intermediate conclusion. One, in his capacity as an employee, Dennis made money only if the investor made money first. Investor has to get paid first for Dennis to make money. That makes their incentives aligned. And then the second box over on the bottom row, in his capacity as an investor, Dennis stood to gain or lose his invested funds, depending on whether the investment succeeded. So therefore, he had the same incentives as the investors, which was to see the investment succeed and for everybody to make money. So those are what the trial lawyer does, is put on evidence supporting those bottom line factual conclusions, and then usually in the closing argument or hopefully earlier as you go through the case presentation, you help the jury kind of go up this chain of inferences from the facts that you're establishing through your evidence to intermediate factual conclusions, and then finally it's going to get tied into a legal conclusion in the closing argument or earlier, and that legal conclusion should align with the jury instructions and verdict forms. That's the fact side on the left side of this chart. On the right side, you need to defend this legal rule that similar incentives to an investor, if the defendant has similar incentives to the investors, then it tends to show that there's no intent or scienter. There, how do you defend a legal rule? The best way, almost always, is to point to a binding statute, a binding contract, or a binding case. And the case should be decided in a similar procedural context. The facts should be analogous. The claim should be the same in most instances. So, for example, we have here in the bottom right box a Ninth Circuit case called Worlds of Wonder Securities Litigation, and a parenthetical saying that the case held that officers of a company had conclusively negated any inference of scienter when they held on to most of their stock and incurred the same large losses as did the plaintiffs themselves. So that language doesn't say anything about incentives by itself. So this is where the legal researcher and analyst skill comes in, of being able to abstract from that fact situation into a general principle, such as this incentives rule, formulate that rule in a way that it can accurately be backed by the case, and then weave it in with the facts. So that's kind of how I think about legal arguments in a nutshell. The core of it. There is also another sort of layer that's helpful in thinking about legal arguments, called argumentation schemes or argument schemes. And I learned about these from a pioneer in informal logic and argumentation, who's also written about legal reasoning, a person named Douglas Walton, who was a Canadian logician, passed away not too long ago. And this book, Argumentation Schemes, is quite good. It's a dense read, but in my book that I'm working on, my next book, I'm going to share some examples of the concept and kind of try to boil down to its essence for legal practitioners. But argument schemes are essentially inference patterns, oftentimes implicit in arguments. And so what Douglas Walton and his colleagues did is to sort of abstract out from many different arguments into sort of generalized argument paradigms. An example familiar to trial lawyers will be arguments from expert opinion. So essentially the argument from an expert opinion looks like this. You say that your witness is an expert in a certain domain, and the witness testifies to a certain fact, that proposition A is known to be true. That proposition is within the expert's domain of expertise, not unrelated. And therefore, you have the defeasible conclusion that fact is probably true. And so what that's going to do is shift that tactical burden to the other side to put up their own expert or challenge this expert's qualifications or otherwise challenge their testimony. So what does that challenge look like? If for each of these argument schemes, Walton generated critical questions, which are the sort of arguments that can be used to rebut the argument scheme or challenge the inference. A couple examples relating to expert testimony are to challenge the idea that the person's an expert at all. Maybe they're not really an expert. Maybe they only have a bachelor's degree in the topic and they've been working in some other field. And then challenging the applicability of the whole domain, whether it even applies in this instance. And then of course a common move that lawyers use every day, the trial lawyers use every day to challenge the other side's witnesses is to look for evidence of bias. Of course, expert witnesses are paid to testify. They're paid to help. They're paid to come to a certain conclusion. And of course, that's just an old standard. Of course, you can always cross-examining the other side's expert, make hay of the fact that, that perhaps they're just saying this because they were paid to. argument schemes are can be thought of as a way to identify legal reasons supporting your conclusion. And there are other ways to identify legal reasons as well. So, for example, you need to go find helpful rules. This is what most legal research projects and assignments amount to. Trying to find the source material from which you can synthesize rules that are correct, will be persuasive to a judge, and intersect with your facts and lead to the conclusion that you want. A big part of that is understanding the hierarchy of authority and then learning how to argue effectively based on those precedents. And that's something that I devote a whole chapter to, chapter 8 in Elliott Legal Writing. Then there's this idea of argument moves. And I note a couple of books there that primarily teach argument moves, among other things, but I'm a big fan of Ross Gruberman's book, Point Made. Read it countless times. I've taught it. And he's been a great mentor for me as I've kind of broken into this field myself. But Point Made, just a simple example of an argument move taught at the beginning of Point Made, is this idea of one fell swoop. So you distinguish a bunch of the opponent's cases at once by finding a common distinguishing factor. That's what I call an argument move. There's also another one by a professor of legal writing at Yale named Messing, and his book is The Art of Advocacy. Both of those books are strong because, like elegant legal writing, they teach by example, showing these techniques in action. So highly recommended. Then you have interpretation techniques whenever interpretation issues are afoot, which is true more often than not in the law. So interpreting statutes, interpreting contracts, and so on. And the best book on that I'm aware of is Garner and Scalia's book, Reading Law. And then as far as policy and value-based arguments, there's a phenomenal book by Ward Farnsworth of the University of Texas School of Law called The Legal Analyst. This book, I think, turbocharged my skills as a 1L when I read it before my 1L year. And it just shows some brilliant ways to integrate thinking about economics and philosophy and other disciplines into and how they operate in legal problems. I want to say one thing about policy arguments too, which is that if you can take the policy argument and instead of treating it as kind of like frosting on the cake, if you can argue correctly that it's part of the rule itself, it's not extraneous, then it's going to be much stronger. And then there are other sources as well. Ideas of classification. How a lot of legal reasoning involves classifying something as one thing versus another. You see this a lot in property law, for example, when you talk about easements. Concepts relating to vagueness. So thinking about what's the appropriate level of generality at which a rule should be discussed. What are the edge cases? Logical fallacies. Rhetoric and persuasive techniques. These are really not going to function as reasons most of the time. However, they kind of can. Like, for example, the rhetorical concept of ethos has to do with your credibility as a speaker and writer and persuader. So it can actually function as kind of an implicit reason backing your arguments. If the court comes to believe that you're going to not get them reversed if they rule for you, because they've come to trust that you are an excellent researcher and an honest advocate who makes sound, not just convenient legal arguments, but sound ones, that can function as an implicit reason for the judge to rule in your favor. Cognitive biases. So best example of this would be using a technique of anchoring, for example, in a mediation to function kind of as a subconscious reason for the other side to settle at a value you find acceptable. And then legal history. So when you make originalist arguments about what a term of art meant at a certain time a statute was enacted, or you talk about how the common law approached a particular problem, and it's been done this way for hundreds of years. So when the other side tells you it's some other way, they're wrong. These are all potential sources from which you can craft good arguments and good based on legally cognizable reasons. And I think almost always the best one is if you have a statute or contract provision directly on point, often in combination with great cases decided in favor of somebody in your client's position with analogous facts and with the cases being published and binding in the jurisdiction. And I'll note that it's helpful. I find it helpful when I teach, and I think my students find it helpful to have kind of a default go-to template, especially for those times when you only have 3 hours to write a motion or a brief. It's sometimes helpful to go in from the beginning with kind of a framework of how to organize it. So what I teach are these frameworks. For point headings, your good default point heading in an argument section will be conclusion plus your best reason, linked by a because statement. And I talk about this in the book. And then for argument sections and subsections, more broadly, they'll start with a conclusion, provide your best reason, and then your second best, and then your third, and then finally rebut the opponent's arguments. They'll vary these to each particular brief, but that's my standard way of doing it. Sometimes an opponent's argument may be sufficiently potentially convincing to a judge that you'll need to rebut it front and center. It has to be adjusted on case by case. So I'm going to take a look at the questions here momentarily, but that concludes the presentation portion of my talk. My book is available. It's affordable. We were able to keep the price down from the University of California Press. So it's a bit, and it's also they were generous enough to be able to license the audio rights, so it's on Audible as well as Kindle and print. And my blog is elegantlegalwriting.com. It's periodically updated, not really when I'm in a trial month, but you'll see if you follow that blog, you're going to see a new material. I don't really very often recycle anything. I get bored by talking about the same things, so you'll increasingly see little drafts I'm testing out from my new research about legal reasoning and so on, as well as new examples of writing principles. I use LinkedIn now. I've been able to become part of this great community of legal writing aficionados and lawyers on LinkedIn, so I would recommend following my account there if you'd like to see what I have to say about legal writing. And my law firm is open for business. We're a business litigation boutique, and I do legal consulting through the law firm, represent clients, both plaintiffs and defendants, and we have a transactional side as well. And then I also do private workshops and speaking engagements for those interested. So with that said, I'll take a look at the questions.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.